I'm David Ward. I'm an attorney at Legal Voice, as well as a member of the Q Law Foundation Board, and I am substituting today for a couple of prior speakers who we've had present on transgender legal issues. We call this section kind of Trans 101. We have an hour, which is really not nearly enough time to give all these issues the coverage they deserve, but we do want to start to identify important ways that as clinic volunteers you can work culturally in a culturally competent and respectful fashion with transgender clients, deal with some of the most common legal issues that transgender people face, and issue spot and direct further resources. In the Seattle clinic, traditionally about 40% of our clients are transgender people. We also do an on-site legal clinic every month in Seattle at the Ingersoll Gender Center, which is a tremendous place. It's been doing support groups for trans folks for decades and was founded by Marcia Botzer, one of the leaders in Washington State's transgender community. We also, I know, have a tremendously vital and large transgender community in Tacoma and Pierce County, and I do think that it's going to be essential if you're volunteering for the clinic that you're able to work respectfully and competently with transgender clients. I want to again give acknowledgments to folks who've done this presentation before me, who I am largely borrowing their materials from. Danny Askini, who was at the she's the executive director of the Gender Justice League and was Q Law's program manager a couple of years ago. We knew we were going to lose Danny because she is incredible, and when we were hiring, I know we said, I think she's going to want to be an executive director of an organization, and I'm glad she is now. And Denise Diskin, who was our clinic manager in the King County program for many years, also has done this presentation before, and both Denise and Danny are highly knowledgeable on transgender legal issues, and I know are going to be resources that folks should feel free to call upon when needed. I did put a handout in from the National Center for Transgender Equality that's a 2-pager that gives some of the most common terms that are important to get a good handle on when working with transgender clients. And it's important to distinguish between things like sexual orientation and gender identity and gender expression in particular. Under our Washington State law against discrimination, as Beth described, sexual orientation is used as a blanket term to describe discrimination both on the basis of being gay or lesbian or bi, as well as based on gender identity or expression. But these are all very different concepts. Sexual orientation, of course, is more about who you are attracted to sexually. Are you attracted to a member of the same sex, a different sex, you may include even being asexual. Gender identity reflects your internal self of gender, who you know yourself to be, regardless of the sex that was assigned to you at birth. And it's important to remember that gender identity is internal. It may not be manifested in any outside way, or you may not feel able to manifest it outside without suffering discrimination, which is a big concern. And gender expression is, again, how we express our gender to the outside world externally, often through how we dress, how we groom ourselves, hair. And gender expression, I think Beth touched on this as well too, also includes people who present themselves in ways that are not stereotypically masculine or feminine, and can cover a wide range of different gender expressions. Our very long definition of sexual orientation under the Washington Law Against Discrimination. As we can see here, sometimes we'll just see shorthand saying that Washington law prohibits discrimination based on sexual orientation, but it really does cover discrimination based on gender identity or expression. The problem is when the legislature defined this form of discrimination, when it passed a bill in 2006, it lumped sexual orientation, gender identity, and gender expression under one term that was defined as sexual orientation. So if you're going through the Washington Code sometimes, you'll just see, like under insurance transactions, it'll say discrimination based on sexual orientation is permitted. And you might think, well, does that cover gender identity or expression? And yes, it does. The problem is it all refers back to the WLAD definition, which is broader. So just wanted to give a heads up then that in case you're ever doing some searches through the Washington Code or sometimes administrative rules, usually when the term sexual orientation is used in the code, it also means gender identity or expression. Now this is just some very basic trans terminology. Some folks, you might have seen the word trans with an asterisk used. That's often used today, or sometimes just trans without the asterisk is used. And that's a blanket or umbrella term to refer to a wide variety of folks who are not gender conforming. It may mean you're transgender, it may mean that you're gender queer, it may mean that you are not identifying with any particular gender at all. And transgender is similarly an umbrella term that is used for people's gender whose gender identity does not match the sex that was assigned to them at birth. I think this is a pretty savvy room, but I didn't put up the term cisgender, but if folks have not heard the term cisgender before, CIS, gender, that's a term that's used to refer to somebody who is not transgender. And the term non-transgender can also be used, and it's sometimes used in materials because it's more easily understood by folks, but cisgender is often a preferred term to use to refer to people who are not transgender. Just some important notes at the outset is, as attorneys and as advocates for transgender people, a lot of the job is about educating people. There is a high level of unfamiliarity with the transgender community in the general population. Even among the most optimistic surveys I've seen, no more than 20% of Americans will say that they know somebody who's transgender. They may know somebody who's transgender, but may not know that that person is transgender. For instance, just like for many years, a lot of people said they didn't know any gays or lesbians, but until people started to identify publicly and come out, that number rose dramatically. But in the transgender community, there's still a huge amount of unfamiliarity among the general public with the transgender community, and that includes the courts, that includes law enforcement, it includes employers. And part of the job as an attorney is to educate those agencies, the courts, about appropriate language, the law, and what it means to be transgender. I did mention language here too, and I think Beth touched on this as well, but it's important as an advocate who works with transgender clients to pay attention to language and to make every effort to use correct and respectful language. That includes, for instance, asking a client what pronouns the client prefers and adhering to that, and to recognize that you will, as an advocate, sometimes make mistakes. And when you make a mistake, the correct response is to acknowledge it, apologize, and to avoid the best you can, do it again, but just recognize it's going to happen. I think sometimes as lawyers, we all want to be perfect. We don't want to make mistakes. And I think the fear of doing that sometimes prevents people from taking steps to work on unfamiliar legal issues or with populations of folks they haven't worked with before. And it's important not to let language become a barrier to working with folks, but also to be mindful of the importance of it. Another note, and it's still pretty true, but it says on the slide, agencies, policies and practices versus statutes. A lot of the development of policies in Washington state and in other government agencies towards transgender people have been developed outside of statutes, have been developed outside of administrative rules. They've developed as policies that agencies have developed over the years, and largely as a result of advocacy, to deal with situations involving transgender people appropriately and respectfully. But it does make it very hard sometimes to do research on these issues, because sometimes you won't be able to find a statute, you won't be able to find a WAC that describes how a situation is supposed to be dealt with. For instance, how the Department of Licensing is supposed to deal with changing a gender marker on a driver's license. That's not in the WACs, it's not in the statutes, it's a policy that's been developed by the agency over the years with advocacy. So it's important to know where to find these resources. Thankfully, more of them are coming available online, where agencies are doing this. But I'd also say part of this was done over the years because we sort of had to work on the down low on these issues for fear of backlash, that if an agency adopted a specific policy on this, it would cause a fair amount of outrage. We saw this happen in Washington less than 10 years ago over Medicaid. it may not have been known, but for many years, Washington's Medicaid program would cover transition-related surgery on a case-by-case basis for transgender people. It was not a formal policy. It was based on medical necessity. And when it came to light among certain folks that the state Medicaid program was covering transition-related surgeries, there was an outrage, and it resulted in 2008 a specific rule being adopted in Washington in the WACs that prohibited Medicaid program from covering transition-related surgeries, something we were just finally able to undo a couple of months ago in Washington after many years of advocacy. So this is just letting folks know this because doing research on these issues, legal research issues on trans issues, can be hard for that reason because you often can't find an affirmative statement of the law on these issues. Now, a big issue for transgender clients, probably the one that we see people the most for at our legal clinic, is how to do document changes. The good news is there are a lot better policies now than there were just even a few years ago on document changes at both the state and federal level. The bad news is that each document issuer has different policies and different processes for how to change both your name and your gender marker on identification documents. We do encourage clients to make a checklist of various documents that they need to get changed. This may include a legal name change, driver's license or identity card, Social Security records and card, passport, and birth certificates are the most common ones. And again, a good tip is just to make plenty of copies of documents as you change them and keep good records on that. Now, name changes. Again, the good news is in Washington, we have a statutory process for changing your name that is relatively straightforward for following and is very widely open. If you're over the age of 18, you can change your name, period, unless your intent to do so is to defraud creditors, which the court will generally make an inquiry about, but it's a fairly easy process in Washington to change your name. We've seen much better practice in courtroom across the state. I'm most familiar with King County, but in King County, our ex parte judges who hear name changes, I haven't heard a bad story about a transgender person experiencing discrimination in that process or unpleasantness for years. So courts are doing this more respectfully and appropriately now, I think. One thing that is a good practice if you're going to do a name change is to, everyone in the country can get a free credit report once a year. And it's a good idea when you're doing a name change to write a letter to every creditor that explains that you are changing your name and giving notice of that. And that's a way, too, to just make sure that you can demonstrate to the court that you don't have any intent to defraud creditors. The other thing I should note in Washington is we do actually allow common law name changes in Washington. You can change I could just start using any name tomorrow if I wanted to, and eventually through the common law it would become a name change. And I think traditionally a lot of women, but some men and in some same-sex couples, people change names after getting married. And you don't really have to go through a formal name change process to do that. But we still advise for transgender clients who are changing their name, particularly if it's a name that does not typically align with the sex that was assigned to them at birth, that doing a name change through the court process is the best and safest way to get that done legally and to not have any questions raised about their names. So I did a little research on this, about the name change process in Pierce County. I wrote down $178, although I saw in another document it said $177 to change your name in Pierce County. So it's one or the other. But the good news is the Pierce County District Court has a page that's devoted to the name change process in Pierce County. And did I put that? Oh, I did put the link up there. And it's very nice because it is very straightforward and describes exactly what you have to do. It's not a contested hearing. It's a process that should be able to be done, just ex parte. In King County, every now and then we have a problem with a judge who will deny a fee waiver to somebody seeking a name change, or I shouldn't say a judge, but usually the clerk's office. Our understanding, and what I've been told, at least in King County by judges in the district court, is that our fee waiver provisions in Washington, which are governed by General Rule 34, should apply to name change petitions as well, and that if you are indigent, you should be able to get a waiver of the fees for a name change if you fill out the required forms by General Rule 34. Now, the name change is usually a key step to take for transgender clients who want to change other identity documents. In Washington State, I will say our Department of Licensing has been great over the years in developing policies for how to change your gender marker and your name on a driver's license or ID card. If you want to change your name on your driver's license, the best practice, actually it's required, is to actually get a name change court order. To do a gender marker change, you will need a letter, to complete a form, as well as a letter from a medical provider. The good news in Washington, too, and this was a result of years of advocacy, is that in order to change your gender marker on a Washington State driver's license or ID card, you do not have to show that you've undergone any surgical procedures. You do need a letter from a medical provider who can assert that you are indeed in the process of, I should say, that you're transitioning from the sex that was assigned to you at birth to a different gender, but you don't need to offer proof of any surgeries. Once the Department of Motor Vehicles is satisfied by the documents you submitted, they'll mail you a letter of confirmation that someone can take to any DMV and get their license updated for $10. Every now and then there are problems with this process, but again, we haven't heard too many complaints in recent years. So just on this slide, it has links to sites for the Washington Department of Licensing where you can download the information about how to change a gender marker on a driver's license, as well as how to do a name change on a driver's license. And Q-Law, as well as the Gender Justice League, are both interested in knowing if clients are encountering any problems in changing gender markers or names on driver's licenses. So you can find both of those places through me, Q-Law, and I can refer to Gender Justice League as needed if there's any problems. Birth certificates. Again, we've had some enormously positive changes in Washington on how to change gender markers on birth certificates. It is possible and not an onerous process in Washington for a transgender person to change the gender marker on their birth certificate to match their gender identity rather than the sex that was assigned at birth. These are done through the Washington State Department of Health's Office of Vital Statistics, and they will amend birth certificates to reflect both name changes and gender identity. Again, to do a name change, you need to get a court order with a name change. And similarly to changing a driver's license, you do not need to show surgical procedures in order to change a gender marker on a Washington birth certificate, but you do have to get a letter from a medical provider that attests to appropriate clinical treatment and the new gender marker. And again, this one, I'm not sure if the Department of Health has this information available online, but they are familiar with this process, and I think it's possible to get information pretty easily by calling the Washington State Department of Health. And there is a resource which I wish I ran out of copies of this resource, but the ACLU of Washington has put together a guide to the rights of transgender people in Washington, which we use at the clinic in King County all the time. I ran out of them at the last clinic we did, and we need to get some more. But this guide was updated last year. I think it was originally done in 2011 as a result of a Q-Law Foundation grant that funded a position at the ACLU of Washington to develop this guide. And it really is a fantastic guide. It walks people through the processes for everything I've just discussed. And it's done in very accessible language, and it's very easy to follow. So for the clinic, I will hope, and you can print out copies online too, but they also put together nice little booklets that are very handy to hand out to people. So that's a great guide. It gets trickier when you're dealing with clients who were born in other states, because the process of changing your name and gender marker on a birth certificate from another state varies widely from state to state. And I will say, even at the last clinic I did at the Ingersoll Gender Center, I got a question about how to change a birth certificate for somebody who's born in the Philippines, and there I was really not sure how to advise and had to do some follow-up work outside the clinic. The good news is there are several organizations have guides on how to change birth certificates on a state-by-state basis. Lambda Legal has a guide. I believe the Transgender Law Center, which is based in the Bay Area, also has a good guide on a state-by-state basis. But really, you just have to go and check the requirements in each state. Some are easy, some are hard, and some just won't do it. So that will be a process that'll be probably require a little bit of extra research if you get a client who wants to know how to change a birth certificate if they were born outside of Washington state. Changing Social Security cards. Under the Obama administration, this has become, again, a much friendlier and easier process for folks to do, but it does have to, again, if you're doing the name change and gender changes on records, you have to do each agency separately. There's not one universal way to change your name or your gender marker on all of these documents. For Social Security, again, the best practice is to get a name change order from a court. And let's see. Again, similar to Washington, there are several different ways you can actually show that your gender has been changed. If you already changed your Washington birth certificate, that can be evidence for a Social Security change. A physician letter can be sufficient. If you've already changed your passport before your Social Security card, your passport can be evidence to support a gender marker change for Social Security. Again, the guide from the ACLU of Washington, excuse me, has this information spelled out pretty well. And again, passports. Again, with a passport, in order to change your name on it, getting a name change from the district court is the way to go. Get your gender marker updated on a passport. A letter from a medical provider is a way to go. And again, you go through the U.S. State Department for that, similar to other changes with passports. So marriage. We used to have a much longer discussion of marriage and transgender people when we did these trainings. As a result of the U.S. Supreme Court's decision in June in the Obergefell versus Hodges cases, it's now very simple. It doesn't matter. If you have transgender clients who are wondering if their marriage to a spouse is legal, if they had transitioned during marriage or before marriage, it doesn't matter. We don't have to answer those questions anymore. There's a lot of litigation, particularly in other states, over whether marriages of transgender people, one transgender spouse to either a cisgender or another transgender spouse, were legal because they were considered same-sex marriages. Not anymore. But if you do ever have anyone raise a question about the legality of a marriage based on somebody's transgender status, please do let us know. Terry touched on these cases a bit, so I'm not going to get into it, but on child custody matters, as Terry pointed out, since 1983, the Washington Supreme Court made it clear that a parent's sexual orientation is not a proper consideration in making child custody determinations. In 2006, Division 3 of the Washington Court of Appeals had a case that raised the question of whether a parent's transgender status was a proper consideration in making child custody determinations. And similarly, the court, looking to the Cabell-Quinto decision from 1983, did also hold that a parent's transgender status is not a proper basis to consider or to hold against somebody in making child custody determinations. It is important on family law issues. I will say this, transgender parents still have a hell of a time in court and face a lot of misunderstanding and face a lot of discrimination. And just as Beth said, how an employer can always find a reason to fire you that looks non-discriminatory, I'd say a family law court can always find a way to rule against you in a custody matter that looks non-discriminatory as well, because none of us are perfect and all of us have done something. But it's important, to go over clients with other factors that might be taken into account in a family law matter in making a determination of residential time. So I'm not going to repeat some of this stuff much because this is stuff that Beth just covered to some extent in her presentation under discrimination. But Beth did focus on employment. It's important to recognize that our Washington law against discrimination does not just prohibit discrimination based on sexual orientation or gender identity or gender expression in employment. It also covers discrimination in health care, insurance, public accommodations, education, credit, and there are other factors that are specifically protected under Washington's law. As Beth mentioned, to file a complaint of discrimination with the Washington State Human Rights Commission, you generally need to do this within 180 days of the last act of discrimination, regardless of the form of discrimination. The exception is you get up to a year for housing discrimination to report that. Now that I look at it, the list that I provided before did not include housing, but yes, housing discrimination is prohibited too under the Washington law against discrimination. And I think the rest of I should also make a point on this. Beth did mention this, but you do not have to file a complaint with the Washington State Human Rights Commission in order to have a right to file an action in court if you're discriminated against based on your sexual orientation, gender identity, or gender expression. The statute of limitations for that is 3 years to file a private lawsuit in court. There is something else that folks should be aware of. The Washington State Human Rights Commission is in the process right now of drafting administrative rules to clarify and provide guidance on the provisions of our law against discrimination as it relates to sexual orientation or gender identity discrimination. They came out with proposed rules in May, and they had the hearing on the proposed rules at the Rainbow Center back in June. They did it the day after Pride weekend in Seattle, which made it difficult for some of us to get our comments in a timely manner, but a lot of organizations joined together to submit comments. The draft rules in general look pretty strong, but we hope that the Human Rights Commission will make them even stronger. We've heard that they are expected to issue final rules before the end of the year. And once those administrative rules are issued, they can provide an even stronger basis to make legal arguments on a number of forms of discrimination under the WLAD. Now, I will confess, I tried to do a section on how you can bring a discrimination claim with the city of Tacoma. And this is based on my website research. So I think for the clinic, we'll want to develop some better materials on this. But the city of Tacoma has a very strong anti-discrimination ordinance as well in its municipal code that prohibits discrimination based on sexual orientation and gender identity. It covers discrimination in housing, employment, public accommodations. And it is possible to file a discrimination lawsuit with Human Rights Division in the city of Tacoma, and they will investigate claims of discrimination. And sometimes you might want to file under the municipal laws because they might cover smaller employers. For an employment discrimination claim under the WLAD, I think it only applies to employers with 8 or more employees, whereas many municipal codes will cover, in Seattle, for instance, it covers even if you have one employer. If you have one employee, you're subject to the city's anti-discrimination law. So sometimes, if an act of discrimination occurs in the city of Tacoma, this is a remedy that people should be aware of, that they can also file complaints with the city based on violations of the municipal ordinance. Now, federal. We've heard for years, and it's been true, I think since the 1970s, the LGBT community has been trying to get a bill through Congress that prohibits discrimination under federal law explicitly based on sexual orientation and on the basis of gender identity or expression. The latest incarnation of this bill in Congress is called the Equality Act. It's languishing in Congress, and we still do not have a federal law that explicitly prohibits discrimination based on sexual orientation or gender identity or expression. The good news, however, is the courts and the administrative agencies at the federal level are starting to understand what many advocates have been arguing for years, and that is federal law does prohibit discrimination based on sex in employment and in housing and in many other categories. And the EEOC, the Equal Employment Opportunity Commission, several years ago, I think it was in 2012, recognized for the first time that discrimination against transgender people, discrimination based on gender identity, is a form of sex discrimination that is prohibited under federal law because it's discrimination based on sex. And there's some movement these days, too, to also recognize that sexual orientation discrimination is a form of sex discrimination. The EEOC is moving on that as well, too. So that does give transgender people who face employment discrimination a basis to file a federal claim with the EEOC for discrimination and to proceed in federal court after they've exhausted their remedies with the EEOC. So that's an important thing to know for transgender folks. There are actually federal protections against employment discrimination because it's a form of discrimination based on sex. The same thing is true with, we believe will be true with healthcare discrimination. The Affordable Care Act, aka Obamacare, included a section called Section 1557. It was the anti-discrimination provision of the Affordable Care Act, or the ACA, and it prohibits discrimination based on sex. And in September of this year, the Department of Health and Human Services proposed rules to implement Section 1557, and they included incredibly great language recognizing that discrimination against transgender people in health care and in health insurance is a form of sex discrimination, and that covered entities under the ACA cannot discriminate against transgender people, and that they can, transgender people who face discrimination by covered entities, which are entities that receive any kind of federal funding, whether through Medicare, Medicaid, or other federal dollars, they can't discriminate against transgender people in healthcare anymore, and that's a very powerful tool. And HUD, the U.S. Department of Housing and Urban Development, has also taken important steps to recognize that prohibitions against sex discrimination in housing apply equally to transgender people. So this is all pretty incredible. It gives transgender people a lot more remedies, and in some cases, I'd say even more. The federal agencies are further ahead in recognizing that discrimination against transgender people is already barred under federal law than they might be on recognizing that discrimination against people based on sexual orientation is prohibited by federal law. A lot of this presentation is based on materials we did at an April CLE in King County, but when I was doing the slides for this one, I knew I had to put in something about the YMCA of Pierce and Kitsap County based on what's been happening here since October 5th. For those who are not familiar with this, on October 5th of this year, the YMCA of Pierce and Kitsap counties announced a policy for locker room access for transgender members as well as transgender employees. And the policy announced that at family facilities, which are defined to include almost all of the facilities in Pierce and Kitsap counties, transgender people in transition must use separate locker room facilities for dressing and showering. And the YMCA, despite getting a lot of feedback from community members and LGBTQ stakeholders, as well as, I believe, the State Human Rights Commission, is adhering to this policy. So, what is happening on this? Well, there was a big community meeting here, I understand, earlier this week on this issue. I know there's a lot of advocacy going on to help to educate the YMCA about the problems legally, not just morally or ethically, with this policy. And I would say, as an attorney who has looked at this policy fairly carefully and has looked at the law, that my interpretation of the law would be that this policy violates Washington's law against discrimination. And I think it will even more clearly violate Washington's law against discrimination once the State Human Rights Commission has issued its final rules interpreting our 2006 anti-discrimination law. The proposed rules that came out by the Human Rights Commission last May were very clear that access to sex-segregated facilities such as locker rooms and restrooms are considered places of public accommodation where you cannot discriminate against people based on their gender identity, and that transgender people under the law must be allowed to use facilities such as locker rooms that match their gender identity. So I would expect there'll be further efforts on this to persuade the YMCA to revise its policy. I would expect in particular, it'd be my great hope that when the final rules come out from the State Human Rights Commission, that they will respect that interpretation, which is consistent with interpretations that have been made under many other state laws. Yesterday I was looking at the Iowa administrative code on this, and they're very clear in Iowa that also prohibits discrimination based on gender identity, that includes being able to use the locker room that conforms to your gender identity. Same thing in Colorado, same thing in California, Delaware, Vermont. Many other states have already interpreted their anti-discrimination laws to include locker room access. And I don't quite know, and I probably should have covered this at the beginning, but the policy is directed at people in transition. And that's something that as attorneys and advocates who are going to be working at the clinic have to understand, that in transition is not a term that is easily defined or understood. I don't know what the YMCA means by that. But in the popular mind, I think a lot of people believe that all transgender people want one thing. They all want to have and I'm going to put this in quotes, a sex change operation to alter their bodies to match the gender identity. That's not true. Transition is a different issue for every person, every transgender person. Not all transgender people want surgeries. Many do, but not all do. Not all want the full range of transition-related surgeries. And that's something to understand too when you're working with transgender clients, some of the terms that are used. I mean, there's top surgery, there's bottom surgery. There's also surgeries such as facial feminization, which are very important for many trans women. Things like a tracheal shave, where an Adam's apple is made less prominent. There is a wide range of different kinds of transition-related surgeries. It's just not one surgery that somebody might have that's a sex change, which I don't think is understood in the popular mind or folks. And there's also, I think, a lot too much of a focus on surgery as transition. Gender identity is not about having surgery. Gender identity is what you know yourself to be internally. But it is, I do think, and this is recognized more and more, that having access to transition-related surgeries is medically necessary for many people, and that it should be covered by insurance, and that's what we're going to get to next. Now, we actually in Seattle last Friday on November 6th had a 4.5-hour CLE on transgender healthcare issues. We're going to make that video available online too. So I'm just going to hit on some of the high points about health insurance coverage for transgender people. But there are enormous amounts of resources and a lot more out there on this, including the other training video that we will, of course, be making available for clinic volunteers here. So what's the state of trans health insurance right now? Well, for private plans, there's a variety of different things. Some policies affirmatively cover transition-related care. It's written into the policies that they cover transition-related surgeries. Other policies don't have any particular language on transgender or care or transition-related surgeries. In those cases, under the plan documents, coverage for transition-related care should be judged under a medical necessity test, because all health insurance plans should cover medically necessary care unless it's specifically excluded. And I'm afraid to say there are still some policies in Washington that have blanket exclusions for transition-related care. Many are very explicit. They will just say, we will not cover sexual reassignment surgery. We will not cover, the wording is different. Some say we will not cover any surgery related to transsexualism or even other services. And those kind of blanket exclusions have been used over the years to deny transgender people a wide range of care, not just including surgeries, but also maybe including things like hormone replacement surgery, as well as mental health counseling to deal with gender dysphoria. More good news on this front legally. For private plans that are sold in Washington, such as a plan that you might buy on Washington's healthcare exchange, Washington's Insurance Commissioner Mike Kreidler issued a letter to all health insurers who are issuing policies sold in Washington in June of 2014 that made it very clear that those plans must not have blanket exclusions on coverage for transgender care under the Washington Law Against Discrimination, as well as under the Federal Affordable Care Act. The OIC followed up its June letter with a series of frequently asked questions. And one of the frequently asked questions made it very explicitly addressed whether health insurance plans in Washington must cover transition-related surgery. And the OIC said a health plan that includes a specific exclusion for sexual reassignment surgery would be an impermissible discriminatory exclusion based upon an enrollee's identification as transgender. So that was very strong, and that was a huge step forward in ensuring that we have inclusive care in Washington for transgender people. Up until this guidance was issued, it was actually impossible in Washington state to buy a plan on the private market here that covered transition-related care, unless the employer or somebody would purchase a separate rider for that kind of care. Every plan issued in the state barred transgender transition-related surgeries. So this was a huge step forward. There are limits to what the actions that our Office of the Insurance Commissioner has taken, however. One important thing to note is the OIC, the Office of the Insurance Commissioner, only regulates private health insurance plans that are sold on the market in Washington. A lot of people are insured through other types of plans, such as public plans, or I'll get into this, or employer-sponsored health plans that they are self-insured that are not sold on the private market. The other issue is, I would say, advocates are still receiving a lot of reports of denial of coverage for transition-related care. Not so much for the things we discussed that are traditionally associated with transition-related care, such as bottom surgery or top surgery, but things like coverage for breast augmentation breast reconstruction for transgender women, facial feminization, tracheal shaves, these kind of procedures. And we're getting a lot of reports of insurers trying to nickel and dime and claim that certain transition-related care is cosmetic rather than medically necessary. And that was a big impetus for us having a training in Seattle last week to deal with this, to help provide more assistance to transgender people who are still getting health insurance denials despite the direction from Washington's insurance commissioner. One option for somebody who feels they've been discriminated against by an insurance plan is to file a complaint with the Office of the Insurance Commissioner. You can do this online. The Office of the Insurance Commissioner has strongly encouraged us to let people know that if they are being discriminated against or feel they've been discriminated against, that they should file a complaint with the OIC. The OIC can't necessarily or does not necessarily resolve all these cases, but if they get a complaint from an insured, they will forward the complaint on to the insurance company and ask for a response. And then if the insurance company responds, they'll send that response on to the insured. In some cases, they may say to the insurance company, we ask you to reconsider this decision. But in other cases, they'll just say, here's what the insurance company sent back. We advise you to hire a lawyer or follow the appeals process. So it's not like the insurance commissioner is necessarily going to step in and be your lawyer or do much about it, but it's still important to file a complaint to make a record of these things. There was also some strong action last summer by Washington's Public Employee Benefits Board, which issues health plans for state workers as well as some local government employees. Last summer, as a result of advocacy, the Washington Public Employee Benefits Board, or PEB, voted for a policy to affirmatively provide coverage for transition-related care for transgender people. And they took that action voluntarily. We didn't have to sue, which is nice, and it was a great victory. And that coverage began January 1st in 2015 under PEBB plans. Self-insured plans that are governed by ERISA. That's a mouthful. Whenever I say ERISA, it always puts little chills down my spine because ERISA is a very complicated area of the law, but it's a very important one to know about when you're advising transgender clients, particularly on health insurance issues. A self-insured plan that's governed by ERISA, an example of this would be most large employers in Washington do not purchase their health insurance from third-party insurance companies. They self-insure. That means they pay out all claims under their employee-sponsored plans themselves from their own funds. And if an employer does that, their health plan is not regulated by the state of Washington. The Office of the Insurance Commissioner has no jurisdiction over those plans. Instead, they're governed under federal law, ERISA, the Employee Retirement Income Security Act of 1974. In Washington state, we are aware of many ERISA-governed plans that continue to have blanket transgender exclusions. In part, I think because the reach of the Office of the Insurance Commissioner's guidance does not reach them. They're governed by federal law. And federal law does not explicitly ban discrimination based on gender identity or expression. The good news, and I think that we're going to be using this more and more as a powerful tool to go after self-insured plans that have blanket exclusions for transgender care, is to use some of the tools we discussed earlier. Section 1557 of the Affordable Care Act is one example, as well as Title VII of the Civil Rights Act of 1964, both of which prohibit discrimination based on sex. And I think there are strong arguments to make, for example, that if an employee-sponsored plan that's provided to workers does not cover transition-related care, or at least purports to bar transition-related care, that's a form of discrimination in the terms and conditions of your employment based on sex. The one other thing I should note about self-insured plans that are governed by ERISA, it's not always easy to tell if it's an ERISA-governed plan. It should be listed in the plan documents, but you would need a client to actually bring that in. A lot of these self-insured plans are actually, the employers will hire third parties like United Healthcare or Premera to administer the plans. So the employee thinks, I'm insured by Premera, and they're really not. Premera is just administering the plan, while they're actually insured through a plan that is being paid, all the claims are being paid for by the employer. So I'm not going to get too deep down this rabbit hole, but we will have training materials for the clinic that explain these things a little bit more clearly. I also did put in a 2-pager about various resources on transgender health insurance issues. I want to touch a little bit on, let me just make sure how much time I got. I'm going to go through this a little bit quickly. I mentioned before that the Department of Health and Human Services recently issued proposed rules to implement Section 1557 of the Affordable Care Act, the non-discrimination provisions of that law. And the rules, again, were great. Very strong recognition that health plans and health providers who discriminate against people because of their transgender status are violating the law. A couple specific things the proposed rules included that were exciting. They made it clear that blanket exclusions of transition-related care are facially discriminatory under the ACA, and that would also be discriminatory to deny or limit coverage for health services used for gender transition when those services would be covered when needed to treat other health conditions. This is what we call the parity argument. And again, it's like if an insurance company will cover, say, if it'll cover a hysterectomy that's medically indicated for a cisgender woman who, for any variety of medical conditions, but will refuse to cover a hysterectomy that's related to transition-related care for a transgender man, we believe that would not be parity in insurance coverage for the same treatment to treat different medical conditions, and that would be discrimination based on gender identity. And there are a variety of other analogies to make. For example, for top surgery, again for trans men, a double mastectomy is covered as a treatment for many medical conditions. It should also be covered for treatment for gender dysphoria for transgender men. And those are just some examples. Now, the Department of Health and Human Services does accept complaints and will investigate complaints about discrimination in health care that's prohibited by the ACA. I've put a link up here about where to go to file that. These complaints are filed with the Office for Civil Rights for the U.S. Department of Health and Human Services. A person who's been discriminated against in health care in violation of ACA Section 1557 also, it appears, will have a private right of action to sue for that. But filing a complaint with the Office for Civil Rights is a way to get the complaint on the radar screen of the federal government as well. So when you're advising clients on health insurance issues, a couple of big things. If you can, ask the client to bring in the plan documents, their health insurance booklet, so you can actually see if there are exclusions in the plan documents related to transgender care, if you can see how they define terms like medical necessary, what's covered, and then very importantly, to find out what the appeals process is for denials of care. Most plans will have fairly strict deadlines. I shouldn't say strict, often it's 180 days to do an internal appeal of a denial of health insurance coverage. And you do need to follow the internal appeals processes spelled out in a health plan before you have a right to, sometimes, especially if it's an ERISA-governed plan, to bring an action in court, and you don't want to miss those deadlines. I did also want to give a note on Medicaid or Apple Health. I alluded to this earlier. I remember I said in 2008, Washington adopted a specific WAC that banned coverage under Medicaid for sex reassignment surgery. 2 months ago, we got that ban lifted after years of advocacy in Washington, and now Apple Health will cover transition-related care. It was a pretty incredible advocacy effort by a lot of organizations for many years. Professor Lisa Brodoff, who many of you may be familiar with, who's a professor at the Seattle University School of Law, was particularly dogged. She represented a client seeking benefits for years through her administrative law clinic with her students, and was a huge driver behind this effort. And I'd say we do now have the best coverage under Medicaid for transition-related care of any state in the country, which is wonderful to see. A few best practices that I just want to cover. Some of these are going to be fairly obvious or covered before. Pronouns. Don't assume you know what pronouns a person prefers. It's always better to ask. When you're working with a transgender client, use the name they want to use. Don't think you have to use their legal name. We don't make them put legal names rather than preferred names on our client intake forms. Recognize that a legal issue is not always tied to a person's transgender status, although it may impact it. Obviously, at the clinic, we see a lot of clients whose legal issues aren't really related to their sexual orientation or gender identity, and don't always assume it's always a trans issue. Don't ask nosy questions that you don't need to ask if you don't need to know. Questions around surgery are particularly inappropriate in most circumstances unless it's relevant. It is relevant in many cases to ask if you've legally changed your name, or if you have legally changed your gender marker name on documents. It's very, very rarely appropriate to ask if they've had particular surgeries. And again, I think I touched on this point earlier, but I just will emphasize it again. Oftentimes when you're looking for an answer about how the law deals with a certain issue related to transgender people, it's not going to be easy to find the answer in the WACS or the administrative code. And I definitely would encourage folks who are working with transgender clients who have questions and can't find the answer not to go down rabbit holes. There are a lot of folks in Washington, there's a growing number of folks in Washington who work on these issues all the time. Beth Barrett Bloom is a great resource. I am happy to be a resource. Danny Eschini, Denise Diskin, we are all happy to be resources on answering legal questions on these issues. Oh, okay. The point here is a best practice is that when people are doing a name change, just be mindful to remind people that they may be asked questions about whether they're trying to commit identity theft or fraud when they're changing a name, and understand that that's an inquiry the court has to make, and it's not going to be targeted at them specifically because they're transgender. And this is a good point, I think, here that Denise included, is the best practice in dealing with, as a gatekeeper, as an attorney, is to provide as little legal information as needed to accomplish the task. And I think that's important to know that with transgender people, it seems like people sometimes feel free to ask as many questions and nosy questions as they think they can, that to treat people like their lives should be an open book. Many of these things are very private, and people do not need to always know all the information about things like, again, surgeries or healthcare treatments. I think it's also important, Denise said, do the research, and that's very true. As attorneys who are working with transgender clients, we are expected to be culturally competent. We are expected to have done some research, to know about the clients, and not expect the clients to educate us about things. This is very common for transgender folks, that they have to educate, almost all of them, many transgender people, for instance, report they have to educate their medical providers about what it means to be transgender or what treatments are appropriate. Should not be up for the clients who you're advising to have them advise you about what the law is on transgender people, or what appropriate uses of names, pronouns, other things are. Just a couple other best practices. When it says you're a gatekeeper, I think that's an important thing to remember is, yes, we serve an important role when we're advising people who come to the clinics. We're viewed as people who are knowledgeable, who can provide useful information to people that's accurate, that they can trust, and also serve as a gatekeeper to refer them to other resources that can help. We've said before, in 30 minutes you can't solve everyone's problems, but you can serve an important function as a gatekeeper to help identify a person's issues, where the law might be able to help them, where they might not have a legal claim, which can, I swear, save people a huge amount of time too. It's important to not talk as a lawyer, to keep your knowledge accessible, make sure people understand what you're describing, not to dismiss anecdotal experiences as like, oh, that's just not common, that's just something that happened. And to keep in mind that not everyone has the resources that you might expect them to have. I've talked to so many people who just think that giving somebody, I shouldn't say this, but I think we have a tendency these days to just think everyone has an email address, everyone has access to a computer, everyone has access to a printer. It's just not true. People often need a lot more support than that. And this will be listed on your handout, but some resources. I do want to again give a special recommendation that the clinic get and have a good copy, a good supply of the ACLU's publication on the rights of transgender people in Washington State, because it really is a very good document that provides much of the information I just provided today. Julie informed me that folks are here. You'll also get a copy in your handouts. Okay, and it'll be downloadable. So I think I have exhausted my resources, and I think I've exhausted my time, and that people are hungry. So if you have any questions, I'll be here for a few minutes after lunch, but otherwise, thank you so much.